Good morning, I'm Marili Myburgh and I'm here with Migael Roos from Marais Inc. in George. Good morning, Migael, how are you?
Thank you for having me. I'm very well, thank you. And you?
Good, thank you.
Yes.
It's a pleasure. It's always nice talking to you and having you here. So Migael specializes in evictions, and I think that is a very important part in terms of the rental industry. You know, unfortunately, landlords sometimes get into a position where they need to consult an eviction attorney. So yeah, Migael, I think if you can maybe tell us a bit more about the process, what it entails.
Okay.
I think if you're, sorry, just to add on, I think starting at the application process, if you've got a good application process, you can eliminate your risk or limit your risk in a sense. Unfortunately, sometimes things still, you know, can happen.
Just before we start, I just want also to give a disclaimer for the viewers.
Yes.
The information that I'm just going to share my experiences with eviction matters and give a little bit of info, but the info shouldn't be isn't intended to be legal advice. So if any of the viewers or anyone have a problem with tenants or anything like that, they really need to go and see an attorney, speak to an attorney, so that they can view the circumstances of the matter and give legal advice regarding to that.
100%.
But I'm going to share my experience with matters such as this, and then we can take it from there.
100%.
So for me, I think it starts even earlier than the application process, or like that is lease needs to be properly managed. So that's the starting point for any successful lease, is for how's it managed. So so I think it starts there. If a lease is properly managed, then you can see if there's going to be problems with a tenant or anything like that, you'll see it coming. Yes. I think it starts there. So just to give a little bit, I'm not going to bore the viewers with with the details, but I'm going to just give a brief background regarding eviction. So in our office, we divide the eviction process in 5 phases. Okay. So the first phase is normally the pre-litigation phase, where you send out notices and to ensure that when you go to court, the time frames that is set out in eviction matters are adhered to. So the first notice that's normally sent is to a tenant. So the tenant will be in arrears with his rental or service charges or anything like that, and then what will happen is you need to advise the tenant that he's in breach of the lease agreement. So that's the first step, is to advise the tenant that you're in breach of the lease agreement, and you need to rectify the breach within, normally in most instances the Consumer Protection Act is applicable to lease agreements. Yes. And most landlords don't know that in privately managed leases. So you normally have to give a tenant 20 business days to rectify the breach of the lease agreement before you can actually cancel a lease agreement.
Yeah, I just want to, can I add into that?
Yes,
I think the thing is, you've actually made a very good point. So people don't know that the Consumer Protection Act is, you know, applicable to lease agreements. So I think a lot of people still think, I can come in, you didn't pay your rent, okay, great, give me the keys, or, you know, I can just come and throw out your things on street. And unfortunately, that's not the situation. So tenants are protected by the Consumer Protection Act, and should a landlord, you know, go the route of not following the correct procedures, they can actually be imprisonated as well, because then they are against
I don't. I wouldn't say that they would, to the sense that they would be imprisonated or something like that, but there will be. There will be consequences if you can state it like that. So you can't go and just cancel a lease agreement with 7 days notice and
you can actually, as far as I understand, you can actually, by not following the correct procedure, you can actually delay the process. Yeah, you
delay the process because what happens is in a lot of instances some of the landlords, they will themselves try to do the eviction process themselves rather than coming to see an attorney. And what happens then, they didn't adhere to the initial time frames. So then when they come to you, you have to literally start the process from the start, because you need to adhere to the time frames that's set out in the by the current legislation.
And I just want to make another point.
law.
As far as I understand, you guys have a very good track record by actually being able to, solve the matter, if I can put it that way, without or before it actually going to the litigation phase. So most of the times, you get it in terms.
We've in the last 4 years, or since February 2021, we've attended to about 55 eviction matters, and we've successfully finalized 54 of them. The one I'm still busy now, so that's the one. Yes. So, but if we've spoken a lot about this, is when to actually go and see an attorney. Yes. So that's one of the. So we work by a rule of thumb is like, if a tenant is for a second or third successful month or continuous month failing to pay his rental, then you need to go and see an attorney, because in my experiences, the tenants barely catch up on their arrear rental. So either formal arrangements must be made for the arrear rental, and you need to then ensure that the remaining months of the lease term that the rental is paid. Yes. And then you have at least an agreement regarding the arrears. But if you can't even, so sometimes the tenants aren't in a position to actually catch up their arrears anymore, and then they just fall behind. And then, especially in privately managed leases, we get it that the landlord comes to us, and then the tenant is in arrears for the last 6 to 9 months. We even had in an instance where it had been more than a year before they actually came to us for assistance.
Yeah, and I think the thing is, people always feel, which is understandable, costs are high. I don't think we're going to go into costs. But the thing is, I think it's a good thing to rather consult your attorney and find out what the costs actually are, because by losing 6 to 9 or 12 months rental, I think you actually lose more than the initial cost would have been if you went to an attorney in the first month. And you at least and I understand. I mean, I think there's a situation where we say that we've got people that has a certain behavior pattern, and that's why credit checks, application process is very important. Then you can kind of cancel that out, limit that risk. But then circumstances do happen. I think COVID is a big thing. I mean, in the last 12, 13 years, we were lucky enough in terms of our processes that I think our success rate was about 98%. In the last, 12, 13 years, which I think is great. But the thing is, we unfortunately, we do see everything can be perfect on paper, but circumstances happen. COVID happened, people lose their jobs, the economic state. So there are circumstances. But the problem is, like you say, being even in arrears for a month. I mean, catching that up, because we've all got a budget. We've all got, the economic state is unfortunately a bit unstable. There's a lot of pressure, but how do you catch that up?
Especially in the high rental. So if you have a high income rental or a higher rental property, then if that guy of that tenant fails to make payment for 2 or 3 months, that's 120,000 rand. So they, in my experiences, I haven't had an instance where they were able to catch up.
To rectify that,
to rectify
and
the
then,
breach,
obviously there's a lot of costs involved and everything as well, so it's...
so normally, in my experience, like we work a lot with you guys, so we get normally when we get evictions from or an instruction from you, from the clients that whose rental you attend to. So in most instances, those tenants, they vacate on the first notice. So it doesn't cost the full process. It's not normally opposed. So it's a quick and easy process. Those tenants move, they make arrangements for the repayment, and in that instances, in most of those instances, we also recover all the legal costs that the landlord paid us.
But I think it's so basically how we work is, just for some clarity, so when a tenant, we also send out a letter of demand from our side, so when a tenant fails to pay, I think we, like you said, acting immediately. So if a tenant is in arrears, even by a few days, we act immediately. And the thing is, but if your lease agreement is in place, your statements is in place, so I think it does. It makes the process a lot easier for the attorney, because you can literally send them all the communication. We can provide you with the statements, with the lease agreements, all those things, and the lease agreement is the backbone of all of this anyway. Okay, so once, I think we've covered a lot now about that first step, which is important, because I think if it's in the owner's interest if at the end of the day a client defaults, and the process can be settled in the first step. But you mentioned that there's 5 steps. So tell us a bit more what happens.
Still in the first step. So if you first need to notify the tenant of the breach, afford him the opportunity to rectify that, and if he doesn't by the set date rectify the breach, then you have to transmit a further notice. In terms of which, how we do it is we send an updated letter of demand stating because normally in those instances the tenants don't pay anymore, so you need to update the statement, send a new letter of demand. You have to cancel the lease agreement, and then you have to also notify. How we do it, we notify all the tenants and also all the occupants living on the premises that they need to, the agreement has been cancelled, and they need to vacate the property by certain.
Okay, so just for clarity, just for the viewers to also understand that, so if it is me, my husband, and my 2 children, for instance, and the lease agreement is on my name, you also need to send notices to my husband and my 2 children, because they need to evict.
Yeah, so if they're a major, so then if they're still minor, they fall under the parents.
That's
but
correct,
if they're major, they or adults, you have to actually add them to the eviction proceedings. So they also need to be evicted.
There's a lot of more, I would say, technicalities that we as the normal people don't always know. Let's say the people on the street don't always know that needs to happen on the back end. So it's quite a complicated process.
Yes. So it really is, and you need to. The thing is with evictions, you need to follow the process from the beginning, because if you make a mistake somewhere, it causes delays, and you need to start the whole process from anew.
That's the thing, and I think that's why it's important that someone needs to specialize in evictions when you use them, for the reason there's certain steps, So I believe that everybody has their specialization field. So I don't believe in one person. That's why we are estate agents. We aren't attorneys. We aren't all of those. We aren't electricians, contractors, all of those things. So that's why it's so important for I think any estate agents to have a good relationship with partners and people in the area, in the industry. And like you guys, you focus. I mean, you're a big firm, but you've got different people that focuses on things, and you specialize in eviction. So I think the point is just, it is such a complicated process that it's important that the person that handles this for you as a landlord needs to know and needs to have the knowledge about exactly how the process works.
It really is like you say. For me, so if I can, rather let me continue with before
I think we'll sit here the entire night. But it's, for me also, it's very interesting, because I think it's always interesting to talk to you and have these conversations. But I think for the viewers, it's important to what are the steps.
Let's say now they fail to vacate the premises. So in my experience, if the landlords and come to us early enough, so there's only 1 or 2 months rental in arrears, then normally in that first phase we have the matter settled. So
that's great.
There's an arrangement in place for the payment of the arrears, so all of that is settled. So, but it's let's say half of the instances, the tenants don't vacate, and then now you have to formally proceed with phase 2. So in our office, phase 2 is when you start drafting the eviction application, the founding affidavit, confirmatory affidavit, and then you have the matter enrolled for a hearing date. So
that's the important part, all the important documents that needs to.
So then you draft the application, set out the grounds for the eviction, and you actually also court, but on this date I want to come to court and see if I can get my eviction order, and then then the matter will be enrolled on a court date. So that would be normally 6 to 8 weeks in advance. And then we start with phase 3. So further to the normal eviction application, you have to approach the court again for directions regarding the service of a Section 4.2 notice. So in terms of the Section 4.2 notice, you have to advise the tenants of their rights. So they have the right to housing in terms of the Constitution. They have the right to apply for legal aid. And also in that notice, you set out their rights, the grounds for the eviction that or the grounds upon which you will request the eviction order, and also you have to again advise them of the court date.
Yes.
And that notice must be served 14 days before the hearing date that you acquired in the main applications.
And that is served by the sheriff?
Yes, that's also served by the sheriff. But in some instances, the normal court rules, it isn't possible for service of that Section 4.2 notice in terms of the court rules. Okay. So then you need to apply to the court to say, but we're requesting that the order be served like this. So then the court will give directions. So you're actually requesting directions from the court regarding the service of that notice. Okay. So it's in essence another application that you need to do to the court, like an interim application, and then you have to serve that notice again before the court date. Okay. And we found also when we have the main application and that Section 4.2 notice served, then a lot of the tenants also they vacate at that stage. Okay. So it's only really a small portion that actually becomes opposed and actually goes to through the full process to court. Okay, so then we come to phase 4, when you actually now on the court date you go to court. Okay. And in a lot of instances you'll find that you don't have much contact with the tenants then. Yes. They just ignore you. But on that court date, some of the tenants then they come to court and they say, but I want to oppose this matter.
Do you get a lot of tenants on the court date that just doesn't show up?
Yes. So so you actually get tenants that don't show up, and then you get your eviction order on that date.
Yeah, and I think that's also, in terms of the tenant, that's actually to their, it's not a positive thing for them not to show up. So actually it's very negative for them. So if they want to oppose, the correct thing is to go to court, lay your grounds. Because as I understand, if they don't show up, you will basically
on that date, then you still need to set out the grounds, proof, and so the court views that to say, definitely. Like we always try to do our work very, very thoroughly, because even we've also had matters where we got the eviction order and then the tenants go and see an attorney. So then they brought an application to stay the execution process in order to appeal the decision. So, but if you do your work properly, the court has had a full view, because they need to look at the circumstances of the tenant. So you'll know from working with us, we try to give the court as much information as possible so that they can make an informed decision regarding the circumstances of the tenants, the prejudice that the landlord is suffering as a result of non-payment and all of that.
And I think sometimes I think a lot of times landlords feel, and you guys would get that opinion a lot, that the law is one-sided and they are favorable to the tenant. But I don't think that it should be viewed that way. I think the process is actually quite a fair process, as you said, because the circumstances of the tenant also needs to be taken into account. So there's, I think for an attorney like yourself, for the court, all of those things, there's a lot of things that needs to be viewed. But at the end of the day, I think the court, I would say the rulings of the court are usually fair, and I think that they, at the end of the day, it's but it's not. I think the point that I want to make is the system is not one-sided. It's not a negative thing. So don't take the law into your own hands.
Yeah, the thing is with the whole process is to ensure that when they grant the eviction order, that won't create a situation where the people or the occupants that's being evicted is left on street.
Yes.
So
and that's
you
true.
need to view the possibility for alternative accommodation and all of that. So that's also, if we can quickly touch on that. In terms of the Act, the PI Act, you need to sometimes obtain reports from the municipality regarding alternative accommodation. So it helps the process if a landlord cancels the agreement, but he comes to you immediately, and you're in from the start, because then sometimes those reports aren't needed. So if a tenant is if you can say it like an illegal occupier in terms of the act now, how it's stated, has been living in the property for less than 6 months, then there's not always, or has been unlawfully occupying the premises or property for less than 6 months, then you don't need a Section 47 report.
Okay.
So, but that's more technical stuff, so I don't think we need to go into
I assume step 5 is then once the court has then given the ruling.
Yes, so then you obtain your eviction order, you have it served upon the tenant stating you need to vacate the premises by a certain date.
And that's usually also, I would say, a fair amount, because obviously the tenant needs to
We always request a month.
Yes.
Sometimes you get the month, sometimes the court says 3 months.
Okay.
We have had instances where the court said 6 months.
And I think that's once again linked to alternative accommodation most of the time.
It depends on the circumstances.
Yeah.
So in instances where we proceeded with the eviction matter where the court granted them 6 months to find accommodation, in that instance, that family grew up in that house. They lived there for 27 years, and we got that eviction order.
Yeah.
So that was So there's a lot of factors that the court takes into consideration when you.
That's very interesting. I think we've touched on a few, I would say, delicate subjects as well, because I think evictions is a very delicate situation. People don't always want to discuss it. Landlords feel, as I said, the law is one-sided. Tenants feel otherwise, So it's quite I think it's a very difficult.
The thing is with evictions, you can't just, in my view, you protect the rights of the landlord. But you still need to look, you're busy evicting a family.
That's the thing.
So we try to see how close we can get the parties to a settlement with avoiding court. But in most instances, I've found that if you can do it like that, the tenant feels looked after, the landlord feels looked after. And you sometimes, not always, but sometimes we're able to negotiate a settlement beneficial to both parties, because proceeding with an eviction matter and you have to evict the people.
I think it's
the sheriff actually physically have to go and evict the people. Just to give you, in some instances, to have, so let's say now we've given notice just to end the discussion regarding the phases and the processes. So now you have had the order served, by the sheriff serves the order on the occupants. They now need to move, let's say now by the end of the month. Now they failed to vacate. Now you physically have to arrange with the sheriff to have to go and evict them physically. But depending on where the property is situated, that will depend. Have an influence on the difficulty of the execution of the order. So we had an instance where we had more than 70 people on site to attend to an eviction order, because you had to get pops there. It was an eviction that we didn't emballay to, and you had to get the police there, the sheriff, and all of these people just to get the people evicted. So if you have to physically go and remove them.
And I think if we can make a call on tenants as well, obviously this is very landlord orientated, and but I think if we can make a call on tenants, for any tenants listening to this and maybe thinking, but this is unfair. If you get yourself into a situation, I think everybody understands that circumstances can happen, but rather go make an arrangement. Call your agent, call your landlord, and see what you can do to make an arrangement. Because what we sometimes get is, once we get to the 3rd or the 4th of the month, and tenants have not paid, and we phone them, and we'll get they wouldn't contact us, and then it would be my employer didn't pay me, or any of those things. But if you came to us, and you actually told us prior, once you realize there's a problem, then the landlord usually understands, because a lot of times it's circumstances beyond your control, and then everybody can come and see, but the landlord has financial obligations. So if you don't pay and you don't make arrangements, they are in a situation that they need to skip on payments due to the non-payment of the tenant. So it is quite a ripple effect. And then I want to touch on something a bit more, I would say, controversial and a touchy subject, but a lot of the times we get landlords that would say, once we do an application process, if the tenant still suffers from COVID, then I would understand it. If it's other things, then I feel, in my opinion, also like you said previously, this is all a discussion about our own experiences. This is not any legal advice or any of that. But in my opinion, if you have not recovered from COVID by this time, I mean, we're 5 years later, will you ever recover from that? Most of the times what I see on credit checks is maybe it started, the bad payment history started in COVID, but it's still going on. It's not a thing that it is only COVID orientated. But I get the feeling that sometimes COVID is still blamed for circumstances when it's actually not COVID's fault.
Yes, like you're more part of the application process. So from my side, I haven't had any issues with people claiming COVID or anything.
As I say, unfortunately, I think that's also a touchy
you
subject.
attend to the applications and see what the people say.
Unfortunately, and we do understand, I mean, we've got single people still, that made arrangements during COVID time, paying off their debts monthly. But really, I mean, I've got all the respect in the world for the people that came, made arrangements, and are keeping to those arrangements monthly. So at the end of the day, so I think COVID was a hectic time. I mean, people were influenced.
Yeah, during that stage, you had to negotiate on behalf of the tenants and the landlords to see how you could get amicable solution to everything, because tenants couldn't pay.
It would just evicting a person due to that, I think that would be unfair. But I think so it's quite interesting that you say, so we get the claims a lot. But COVID happened. But I think the thing is really looking once again for landlords. COVID is not. I don't think COVID can really be blamed at this stage anymore. I think we've passed that. And really, if COVID comes up, to really investigate. Is it really COVID, or is it, an easy excuse at the end of the day? So as I say, sometimes in these discussions we do come up blunt, but the thing is, this is important information, and I think just sharing our knowledge with the public, how we see things, I think this is vital information for a landlord, but also for a tenant.
Yeah, so I think that for a landlord, you have to do everything in your... when you vet a tenant, you need to do it to an extent, because no landlord enters a lease thinking that you'll someday have to evict this tenant. So that's where if you do your vetting properly, then you better your chances for avoiding future eviction.
Definitely, and I think vetting does not only include credit checks, previous rental references, but affordability. So a lot of times, I think in George as well, so obviously we are Steve George, situated in George, you guys are situated in George, so you know what the rental market and rental prices in George are. So unfortunately, looking at salaries and rental prices, affordability is a challenge a lot of the times. But placing a tenant into a property where affordability is not sufficient, unfortunately, can also result
because it takes one doctor's account and then that tenant is in arrears. So just to recap from our side is when you do your vetting properly, then you better your chances. If you foresee a problem or start having problems, engage an attorney or if your property or rental is managed, follow the advice of the rental agent. Don't try to do the eviction process yourself. And so that's just from our side.
100%. Thank you so much, Migael. It was such a pleasure to have you here.
Pleasure to be here.
And I'm sure that everybody really got some great advice out of this conversation. And so just once again, Migael Roos from Marais Incorporated in George. Their offices is situated in York Street. So if you ever need their assistance, they do other things as well. But Migael is a specialist in terms of evictions. So but thank you so much, Migael.
Thank you for having me.
For your time.
Thank you. Thank you.
Thank you.
Thank you.